Good morning. Good day. Sorry for the delay.
Lordship, Miss, may I make a mention?
Yeah.
What has happened? A matter relating to disqualification of a serpent. A confirmed.
Do you want posting or adjournment?
It's a posting for hearing.
Which date you want?
My, your Lordship may take up next week. Any day your Lordship pleases. My Lord, I am praying, humbly praying. But this matter was directed to be listed in top 5 by this noble court by virtue of a judicial order.
So next week, somewhere. First July, we say. First July.
So grateful, man. So grateful.
Pardon me. Phase 4.
Any motions?
May I mention?
Writ appeal has been filed since the month of August 2024. But the matter
Not posted for admission.
No,
Post. Give me.
My lords, may I seek leave of the court to appear in virtual mode, lordships, to mention?
Yes.
My lords, this writ appeal number 1323 and 814 of 2023, lordships, it is a single judge order which has confirmed that pharmacist appointments regularization. My lords,
You want adjournment?
No, my lords, I want a posting on Tuesday, lordships.
When do you want?
1st July, lordships. Physically, I will appear, lordships. 1st July, lordships.
1st July.
Tuesday.
All right.
Grateful, lordships.
Inform your friend also.
My associate will supply the intimate.
Just like kindly wait for adjournments. We are accepting memos with
Motions?
Yes.
Just to note the adjournments, then.
My Lord, challenging the judgment of the family court order.
What do you want? Adjournment or
Listing.
posting?
Listing.
Give.
3 matters at a time. Waited for
Just
the
spread lines.
spread कर दे spread. Give up. तुम्ही एका दिना expect करून तुम्ही unless connected.
Yes.
Phase 4, item 30, my lord.
Phase 1. Call phase 1. Phase 1, phase 2, phase 3, phase 4, like that. Yes.
Phase 1, item number 1 to 7.
Item 7 में लेकिन 22 withdraw.
You want to withdraw? Immediately we'll do it. Come on. My colleague. The appellant has filed a memo dated so and so, seeking leave of the court to withdraw the appeal. First off, memo reads as under. Any opponent opposes that?
No, nobody has appealed.
Very good. There is no impediment for according the relief as sought for in the memo, since he is the dominant litis in this court who has right to institute litigation, which includes right to withdraw the same unconditionally. First off, in the above circumstances, appeal is disposed of as having been withdrawn. Okay.
Phase 2, serial number 8 to 15. My lord, serial number 8. Here I am for the respondent and I have also filed caveat, my lord. The appellant it may be directed to serve me a copy of the
Survey copy.
my lord.
All right, so that he will read it and come back.
Yes, ma'am.
Which date?
Yes, as your lordship pleases.
In the third week of July?
Yes, my lord.
All right, third week of July. As consensually requested. Okay.
Phase 3, item number 16 to 23. Phase 4, item number 24 to 30.
My lord, 30, my lord. I prayed 2 weeks after, my lord.
You want to, it is to
My lord, sir, I have read it. Yes, so that's why the short time may be
for preparation.
Sort of.
On 1st of July, we'll have to, 11 years are over.
My lord, that is true. Everything I have completed, but I have not really prepared. So that's why 10 days after.
We are giving you.
My lord.
Even when we grant you relief, you want to argue.
My lord, 10
Which
days.
date? Choose a date.
And it meant 10 days after, my lord.
Morning, you should not spend more time in motion.
Most, my lord. 8th, my lord. July.
All right, July.
8th July.
Finally, at the request of. Yes.
31, my lord.
Huh?
Yes, sir. 31.
31.
Sierra LLP.
Correct.
Your record has been called for. My lord, fixed for hearing any day.
We had asked you a few questions. He cited one 1980 judgment.
Yes, my lord. We
There
are
is lot
ready
of-
with this judgment.
So if you are ready, we'll take this matter now. If not ready, we'll give a date to you.
My lord, give
To
me
which dates other matters are posted?
other matters are only just urgent matter to week after.
Is it?
Today is also two
You
matters.
give one number. We'll call that date at least. Call after 2 weeks.
We get the judgment,
request of,
but
so in
note has
final-
not been prepared.
Huh?
Get the
Note has
judgment.
not- get the
Around 10
judgment.
judgments are there.
Note has not been.
There is lot of development of law.
Yes.
Yesterday, just I
Even in
examined.
2025.
Therefore, just come. You have to go to the graphical movement of the law.
Exactly.
Okay, law is not a static water. It is not a static.
It starts from-
It's a flowing.
and then
It's a flowing Ganga.
80 to 2025 SEC online.
You give citation to my court officers so that
Okay.
people will read and compare.
I've got the printed one. I can.
Okay. Any day, whichever. Okay.
Page 6, page 5.
Page 5.
Page 5, item 33.
33.
Yes.
2019 matter.
Yes.
Let's,
Connected.
my Lord Justice Sahoo,
Order is by my brother.
No, he was a conducting counsel at the time.
Counsel.
File income.
For this state.
Post this matter before a bench that does not comprise of Honorable Justice Sahoo. Okay.
Page 6, serial number 34 to 37. Yes,
34 Millers, similar issue Millers. LCR has come Millers. I will not get copy of the LCR. So that is the question you Lordship put.
You want to go through LCR?
Yes.
you can avail, you can order to avail the soft copy or you can get it.
Well, a soft copy. I will give
Soft copy.
Soft copy it will be.
Registry to furnish soft copy of TCR to the advocates appearing for the parties if they apply for.
In 31 also same.
31 also same.
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 Because the LCR has been called.
Next.
Page number 7, serial number 38 to 34.
44, my lord. 45 up to 2.
44.
And for the appellate.
You are for the appellate.
Respondent is present. Hearing matter.
My lord?
This is a hearing matter. Have you put your learned colleague
No,
On
my lord,
notice.
we do not have an obligation to know him. First time he is appearing.
It has come for hearing. 2024 matter has come for hearing and 2012 matter is still pending for admission.
Is it matrimonial?
Matrimonial.
Is it matrimonial?
No, but you can't jump the queue. What others will feel? Other litigants who are waiting in the queue will mistake the judges, maybe lawyers also.
My lord.
Post this matter in usual course. In usual course. Okay.
Muktam 31. It is taken up next week.
31.
41.
4-1.
Yes.
Next week you want.
It would be better if you take notice afresh. After 7 years, it is coming for hearing.
It is drawn on
No one has appeared.
last
Take first steps.
Better.
step already taken on
Correct.
They have taken now.
Correct, Madam Sinha. We are getting
11/4/2025.
When it
But
was.
the first second time.
10, 12, 20. You take one more notice because clients will not be knowing. It's marriage is the question, na? Plan to take fresh steps. Police notice to the respondent. Respondent.
You have to file litigants in the registry with a memo that was one should.
Appellant to file requisite in that regard.
That's the process.
Okay. Yes.
Item 45.
Of this court, I intimated the same to learned DSGI and he has filed a memo that he is no more the advocate for the appellant.
Who appears?
None appears with respect to the history.
He has filed a memo. Deletion of his name.
My lord.
No, he has to take permission of the court. You cannot unilaterally retire from the case. That's not the law. It is a discretionary power of the court to permit retirement or not. So kindly inform him to come and make submission. It's over, pass over.
Yeah, 2013 matter, the file is misplaced and I have to also take instruction from the client bank.
What happened to that main matter?
Lordship, actually, I don't have any idea. Regarding 2013 matter. That's why I have to take instruction from the client.
At the request of learned counsel appearing for the appellant, 1 week finally is granted.
I prefer 2 weeks, madam.
2 weeks,
Yes.
2 weeks granted to take instructions and argue. Okay, that's the previous discussion. Next. Next.
Yes, sir. I don't know the name.
May I please show them?
Yes, sir. What further order, brother?
And here I am challenging the order passed by the Honorable Single Judge, who has passed the order without taking into consideration statute, that is 16C, Hindu Adoption and Maintenance Act.
16.
16(6).
6.
That
What it says?
That is says that about the registered adoption deed. What is the position of the registered adoption deed? And here is a minor. I have given my whole case is based upon the registered adoption deed, and without taking into consideration that the said authorities has approved it and directed that to pay the mother of the child the maintenance. I have annex. Minor, can you see?
Which page?
Minor.
You are challenging single judge's order dated?
Dated, Minor 9.
Go to single judge's order.
Minor dated 9/10/2023.
Page number?
Page number 34.
Go to page 30.
Family pension to an adopted child, minor child.
Adoption took place at what age?
That adoption took place, he was about 9.
9 years.
9 years.
And the deed of adoption is dated?
Dated minor. Annexure 1. 17/6/82. 17/6.
When you entered the service?
I may be excused. This is 7/9/2005. This is a certified copy.
Date of appointment is?
Date of
appointment.
I beg pardon, my lord. That is annexure 1.
Date, sir. Date cannot be annexed, sir.
Again, sorry, this is annexure 2, 7/3/2012. Date of that deed of adoption. 7/3/2002.
When appointment was done? This is a case of family pension.
Minor.
Family pension.
Person's adoption.
Sir, appointment of the
Appointment is very well.
to be sure about
That is 82.
When he was appointed, when death took place?
Took place, my lord. I believe that's okay.
It took place on 2nd of February 2013.
13.
19/2/2013.
19
Annexure 3, page 20.
He died on 19/2/2013.
Ma'am.
How?
92 would be the date of death certificate. Date of death, look at
2/2/2002
it is. All right. Date of adoption is?
Date of adoption is 7/3/2012.
7/3/2012. When the deed was registered?
My lord, registered.
Whether adoption is compulsorily registrable in your state.
Yes, ma'am.
Registered on?
7/3/2012.
Drawn on same day.
Same day.
Whether adoptive child is entitled to family pension. What's the law on the point?
My lord, minor child is entitled to get
Minor child, all right. Whether adoptive child.
Minor child is.
What is section 16 says? You were saying that. How this court, Orissa High Court has held it, this question is answered. Who appears for the other side?
Other side is.
Not there. Who is the other side?
Man was appearing in the petition.
Minor, may I place the minor was accepted by composition and minor just operating part.
Sir, you have gone far. You have left us behind. We are still at the basic point.
You are for university opponent.
I am for this adopted child company. In the case of Mrs. Deo and others, Lakshminaran, in view of section 16, aforesaid whenever any document registered under any law for the timing in force.
Section cannot be like that. It must be commentary you are reading. Section cannot be.
16:6, my lord, I am reading. 16 is presumption as to registered document relating to adoption. My lord.
Yeah.
Whenever any document. 16, whenever any document.
It gives presumptive validity on registration.
Registration.
Shall be deemed to be presumed to be valid. Why they say they don't want to act upon?
My lord, they accepted it. My lord, operating part, if my lord will place, my lord will be, I think I will be in a position to convince my lord that is the work. Let me place the operating part of the judgment. Documents be found to be genuine and lawful. There shall be no justificable reason for the opposite parties to withhold the disbursement of the pensionary benefit in favor of the petitioner. This observation has been made by the way. Accordingly, this writ petition is hereby dismissed.
Reasoning supports you, but penal law goes against.
And what my lord, thereafter what they are done. And the district magistrate is directed to, after dismissing the writ petition, district magistrate is directed to conduct a detailed verification of the authorities of the petition or adoption.
Yeah, the word dismissal, allowed, rejected, dropped, they have no meaning. We don't touch to apex wholesale. We have to consume order by reading it in a wholesale. Some words will not be.
My lord, here touching on the point, I have referred a judgment and my lord was pleased to refer. My lord, kindly peruse this judgment of the Honorable Apex Court.
Once.
This is touching on the point. My case is wholly dependent on just like this case. My lord, kindly see. Very short judgment. I have a
Section
16:6.
The police and fiction rules provides the entitlement of the beneficiary.
That I have.
Here you are referred to separation rules. Which rule?
That I have to.
Whether the son, daughter, are they defined under the pension rules?
No.
They are defined.
They are defined. That was section.
Subsection 6. Subsection 6.
Section 50, subsection 6.
Section. Rule. That's all. We want 9 rules.
Civil service can see this code. What else?
The definition clauses in rule 2 are based on the. It cannot be all different. Zero. Odisha pension rules, are they applicable to respond
Minor dependent, all the dependent. All the dependents is entitled.
The OCS pension rule is applicable to your
Yes,
this is service.
this is service. Because I was working as a government servant, CESCO, under the CESCO. Then after it has been taken by the startup power.
CESCO means the law Sahoo is not come.
It's one of the corporation of the government adopted by all the system is prepared. I have referred that.
Sukhdev Singh versus Gendram. Supreme Court say the corporations in public sector undertaking are not part of the government. They are not part of the government. Therefore, employees working in a corporation are not civil servants. These rules apply to civil servants. I read one particular rule here. It says it is applicable to civil servants. But if these rules are adopted by the Cisco, then these rules will apply.
I may be excused. For one point, I will clarify this. Kindly see the page 23. They have approved they have directed to pay me. Then after this thing has come, page 23 will clarify everything, madam.
Right to pension, which are the rules? Right to family pension. You are before the
They have approved and you are satisfied by your challenging that. So after they have rejected or not challenging that, so then come up with a case. So please find out the rule where it is mentioned that who are entitled to receive pension.
We are asking first a basic question, whether son includes adoptive son in the rules. How this question is answered by various judges of this court. This court was determined in 38. Is it not that for the first time?
No, that I do. Yes.
Just see that. What time? Short information.
Maybe so page 23, then after whatever my lord will please to pass.
We believe it, sir.
The question is,
what is the language they have mentioned? They have
granted you pension, but still you are agreed and came to court. Obviously, you came to court because they withdrew the pension. Or they did not pension.
Previous concern, CESCO has accepted my condition and directed me that to pay the pension. Then after this Tata power has come, things has been changed.
We are asking national. This is a court of. Court understands language.
My lord, then I'll come up.
We are not Mughal court. Is it? We are not home court. Therefore, he should show whether an adoptive son is son within the definition of pension. Number, whether these pension rules are applicable to the employer organization. Because these rules are promulgated under proviso to Article 309 of the Constitution. 309 rules apply only to the state civil servants, not rules. There are such judgments of this rule. Therefore, you answer this foundational.
I answer.
Then we go for the
one information for you, CESCO has never a publishing
Here my question is that he is only question that adoption did.
Your merchants will address, provided should pass you.
That thing has been, that's the way to do the that thing has been.
We are this side of Mahanadi. You are that side of Mahanadi.
I'm very much obliged, my lord. Obliged. But here question is only their question the adoption. Here did. Nothing is there.
In that case, period of Mahanadi to answer the following questions. Whether the son includes adoptive son in the terminology of pension rules. Number two, whether the Orissa whether services into brackets pension rules 1992 are applicable to the organization in which the TC was employed. What? If these questions on property in one service, maybe nine. Yeah.
Some assistant has been provided my brother, which speaks that adopted son is also entitled to get the.
The second question is, if you answer that.
So your brother has not given you the rule.
Rule based.
Brother feels is happy that adoptive son. So we are very sure that adoptive, maybe I am sure that adoptive son is entitled.
Because General Clauses Act but defines adoptive son.
Your rule is applicable to.
But you have to go to the rule. It defines the beneficiaries.
Your rule. Your rule. Upon General Clauses Act 1897. Anybody in the court house, whether son or daughter or defined in the General Clauses Act. Are they defined? No. Not defined. Not defined. Not defined. In some rule, there is definition. Since it's not included. Died on which side?
Mother died, mother still alive.
When mother is alive, so child will be entitled to which?
Child is, he is looking after. This mother is original mother, adopted mother is has been dead.
This concept of original and
Adoptive mother is dead. Adoptive mother since long.
Adoptive mother is dead.
Dead. When the father died, that I have to come up. When the father has adopted, that time adoptive mother has been dead. Nobody was there with mother. That is the ground I have taken.
Mother predeceased the employee. Predeceased the employee.
so what was the entry made in the pension paper?
I will come up. When there was some time, this
All these questions you are asking. You have seen now, we need not record it, not record.
Money.
It is available online. Okay. Call this matter next week.
One week after. Next week I find. Let it come, I know, one week after.
Whichever.
1 week after.
What each?
Okay. All right.
Oblige.
Yes, sir.
Was engaged as a daily wager, temporary class 4 employee in the.
On what ground learned single judge denied relief to you?
Man, I'm just pointing out that. In 2011, they brought in a notification to regularize employees, these kind of employees who have completed 5 years of service in pursuance of the decision of Honorable Appeal Court in a different context. Now, what has happened? So far as my case is concerned, the concerned branch manager, in my application certified that I have been working since 1/4/2004. That means by the time 2011, I had completed 5 years of service.
Which are those rules which provide for regularization?
That is the notification under Annexure 1.
Notification?
Annexure 1 to the writ appeal, Your Lordship.
That notification is issued under which law?
Man, that was issued in pursuance of the decision of the, that has been mentioned there, page 14, Your Lordship, may kindly turn to. Page 14. That was in pursuance of the decision of the Honorable Appeal Court in the context of this regularization of daily wages, and certain directions were issued, and that is how this has been issued. The most important thing is your lordship will see in clause
As on 18/1/2011.
Much obliged, ma'am. Now, there are two documents on record where the branch manager has said in writing that I joined in 1/4/2004.
Your salary was paid by what mode?
Now, that was in a mode of slips, not in any
Pay slips.
register. Yes, that register happens only after 2008-9 and up to 2009, in view of shifting of the branch from the temporary rented building to the permanent building, the records were destroyed. There are two written documents available on record of the branch manager and show that I have joined in 2004. One is, your lordship, I'll just show two documents, then assist your lordship on the point. Page 22, your lordship may kindly see.
No, we believe you. The that branch manager said that you were working.
Not only gave me an experience certificate saying that I have joined in 2004, in response to the division office letter also, the branch manager said that I have joined in 2004.
When he was there. The branch manager was there when the person who authored that certificate. Was he there as on that date?
As on that date, he was very much there because he has written a mail to the division office saying that I am in 2004. Division office wrote a letter. Who are the temporary employees still engaged in your office? And whether you have given any appointment after 2011. 2011 is the notification under Annex 1. The branch office replies to the division office saying there are two employees. One is this Vibhuti Bhushan Pati and the other one is Manas Kumar Mahapatra. And this Vibhuti Bhushan Pati joined in 1/4/2004.
1 second. There were other daily wages also.
Two only. Present appellant and one more.
All right. It's a life insurance corporation.
Yes.
It's a statutory body.
Yes.
LIC of India Act.
Yes.
Is it not?
Yes.
It would make the payment by check. Salary will be paid by check. It cannot be by money.
No, I beg to clarify this. There are two documents to indicate that I have joined in 2004. Now, what has happened? What is the basis on which my claim has been rejected? I was not called for interview, the consideration in pursuance of Annex 1. I moved Disciplinary Court filing a writ petition that taking steps to terminate me, and despite me qualifying the 5-year service, I am not considered. Now, Disciplinary Court granted me an interim protection. The case was, notice was issued to the LIC. Now, LIC files a response saying that these documents were erroneously issued. They are not saying that the documents were wrong or false or anything. They say this was erroneously issued. These documents were issued in due discharge of public duty because one is experience certificate issued to me when I applied in pursuance of Annex 1. The second is in response to the division office mail that who are the temporary employees. So these are in due discharge of duty in due course. Now in an affidavit you say these documents are wrong and that is accepted and my claim is rejected. That's what I beg to submit.
Who appears for the LIC?
LIC, Mr. Sakti Panda was appearing, madam. But this is a fresh case, Your Honor.
Emergent notice. Panel advocates are there.
Madam, if your lordship directs, I'll serve on the panel advocate. Otherwise, Mr. Panda was there. If your lordship permits, I'll serve on him.
In addition to taking usual steps, petitioner to appellant to serve a copy of appeal paper book on the counsel who represented the respondent LIC before the learned single judge.
Learning process for artists.
It's a learning process for everyone. If he satisfies the other two requirements your lordship has been pleased to frame, then this has to be a purposive interpretation to include him.
And the principle is given to the mother. Then if the mother dies, then what are the contingencies?
Yes, that will arise. And the and
it includes
exactly
where personal law permits adoption.
Yes. And one more thing would be, which my friend, I will definitely assist my inform my land friend, there may be a rule in place for this SESCO itself with regard to grant of annual pension.
That is the point.
Yes, that I'll tell him. He just left. I'll inform him.
I don't know why the CESCO is having its own pension.
Yes.
Then we have to all.
As my lord was pleased to observe, they might have adopted, or they may be having a separate rule in place. Otherwise, they could not have proceeded to approve his case.
But he did not catch or he thought that the adoption, we were referring to adoption of the child. When we were saying adoption of the rules by the employer.
Exactly, you lordship.
That way.
Exactly.
Maybe we failed in our communication.
No, it's not that way. At times we fail, my lord. That happens. I just observing because I was also learning. When you are sitting in court.
Yes, position, this position. We are permanent students.
And when we are sitting in court.
Every case we learn.
And whether we are concerned with the case or not, we should learn also.
We should learn.
That is what I imbibe to my kids.
Kindly take note of Miller's year 1970 Supreme Court 343. Yes. I will not go on through the entire judgment. Just
look into it.
Yes. Yes.
And
including adopters.
In my appeal, I pray for a shortage because on 16/12 they took away my job. I'm a Delhi waiter. Just to survive my family, I was there.
But you did not have interim order at the hands of the single.
No, interim order was there. I was protected, your lordship, throughout. Pursuant to the impugned judgment, they have taken away my job.
I want to say that they even took away the earlier job they didn't regularize.
No, they took away my job also. Yes. I have been continuing since at least 2008 as per their own admission.
Look at the application for the present subjects, and we agree with that. Since it's very enjoying the interim relief at the hands of the government single judge, the same needs to be continued. It needs to be the state of the with the right to seek modification to be granted to the other side. First, we order accordingly.
So grateful. Grateful, man. I pray for ordering.
Item 11.
Yes.
But in this case, I'm challenging the order of the Honorable Single Judge, whereby he has granted the action of the opposite parties, whereby the opposite parties, the respondents in this case, have cancelled being administrators of a particular department, that is Airport Authority of India. By an administrative order, they have cancelled an act of the Parliament, and that has been upheld by the Honorable Single Judge.
Act of the Parliament is silenced by the, killed by the executive. How it is? Just show that.
The story in short, you have to also is synopsis would suffice.
Yes.
There were two branches.
Dr. Misra, I was the counsel in the writ petition.
Very well. Same order. Push this matter before a bench, not comprising of brother judge.
Honorable Justice, date will be fixed for that.
How? Well, the Honorable Chief Justice has to do it. Now, after taking appropriate order at the hands of Honorable the Chief Justice. Earlier order also see. Okay.
I don't well.
The petitioner is an institution which wanted to shift to a new location. As per 2001 guidelines and Annexure 1, page 11, the shifting was permissible. And pursuant to that, shifting for the institution was allowed.
Is it an educational institution? Shifting from one place to another?
One place to another. 2001 guidelines permitted this.
Permit shifting.
Permitted shifting. It was allowed in 2022 at my request.
It was allowed?
Allowed at my request that as per 2001 circular guidelines, you can shift. It was allowed. NOC was granted. Thereafter, 2023 circular came into effect, Annexure 5, page 16.
What it says?
It says that complete shifting should not be done.
Within the same block, it should be.
Yes. My lord, I have made an application that 2001 circular applies to me and 2023 doesn't apply. That application is pending consideration at Annexure 7, page 25.
So what you say is your right to seek permission for shifting has to be governed by the earlier circular.
Earlier circular,
not this circular.
Because in 2022, they had granted NOC for.
To others, they had granted. Anyone other?
Yes, and me also, my lord.
Whether this circular is a retrospective in operation?
My lord,
no, me also they granted.
my lord, I am appearing on behalf of Mr.
Now they say this is beyond the block and therefore will not permit
Yes.
it. Your short question is whether this clarificatory circular
will applies to me or not.
It applies to you or not?
Once they have granted it in 22, now by virtue of 23, they cannot stop me. And that is pending.
They had granted you permission also.
Yes, Annexure.
One second. Kindly understand.
Yes, ma'am.
And answer should be binary. Yes or no.
Yes,
Sorry, not necessary.
Yes,
Just
sir.
judge wants it.
Yes, sir.
So you are permitted to shift.
Yes.
You are permitted to shift when?
Sir, it is on 16/3/2022. Annexure 3, page 14.
16/3/2022, you are permitted to shift.
Yes.
Yeah, and you did not shift at that time.
My lord, the other portion,
Within what period it should be shifted?
my lord, it has not been given.
So you will take 5 years for shifting.
No, immediately 2023 circular came. And I moved that I have been granted. So now I.
Suppose, just clarify, because 22 is state government.
Yes.
The circular is clarificatory circular.
Yes.
Is by the central government.
Central government.
So it clarifies the central government circular.
Central government 2001 circular, 2021 circular was there, my lord.
Whatever, sir. Is it your case that this clarification takes away the right accrued in the original circular? Then you show those two paragraphs only.
My lord, may kindly see.
21 where it permitted and 23 where it takes away.
Yes. My lord, may kindly
Because that
see.
was the questions asked to you.
My lord may see it.
And these circulars are issued under which provision of law?
My lord, they have been issued by the Skill Development and Entrepreneur Department, Government of India.
No, under which statute? We are not the author. We are on authority.
That I have to, which authority they have. That I have to, sir.
Who appears for government? But you have already been, he has already been granted the permission to shift. Who appears for the other side?
Union of India.
Well, Director of Technical Education is to consider his application.
Correct.
And I am for Union of India. We have issued the circular. And that they have to carry out.
No. They will first give the NOC. Annexure 7.
They have made the application to the Director of Technical Education, man.
They have made the
New Delhi. Annexure 7.
Annexure
7, page 25.
Director General DGT, New Delhi.
New Delhi.
This application is made to the Director General.
Yes.
Who is the authority to grant the permission?
Union of India will grant NOC, and as per the NOC granted by the state government, I will shift, because this 23 circular is by the central government. I have mentioned that.
It has come for first time or is for a hearing? Fresh matter. You take this, take notice matter. Requires consideration. Issue emergent notice. Learned Mishra is DSG.
But Union of India. Senior panel council.
Learned Senior Panel Council is requested to accept notice for all respondents.
No, madam. Copy number 1.
Copy number 1.
Who is appearing in this?
AGA. Shripad.
No, they are not.
Yes, sir, I'm sir.
I'll give one more copy.
Yes, I'll give one more.
AGA is requested to accept notice for second respondent number 2. Respond. This is the only matter. Once rights accrue by subsequent circular, you cannot diminish them. That's the general law. Therefore,
Can they be
restricted
if once they have?
You cannot do that. The subsequent circular of the central government cannot.
And he had applied before the circular.
But before the circular. Circular is clarificatory in nature, but whether it is clarificatory or not, we have to see. If circular is clarificatory, it is retrospective in operation. If circular, though it tells that it is a clarificatory, but it is not, then it is prospective in operation. You can't just by branding it clarificatory, you cannot apply it that way. Anyway.
My lord, I only play before your lordship, sir.
Yes.
That your lordship may take up as
Earliest.
because my institution is
Well,
not.
because we are agreeable, still because.
No, I should say my difficulties.
We are agreeable.
You too.
My lord, I am to give justice to myself also.
No, you see, Mahatma Gandhi said, where one word is sufficient, employing two is uneconomic and unwise. This is the statement which Bertrand Russell, the great scholar, philosopher, mathematician, he approved it. Therefore, we should not talk more. Whatever is necessary, we should talk. Okay. Which date you want?
My lord's convenience.
Whichever date we are always here. You say whichever date you want.
Sir, can it be on 7th
You
month?
want to file objections?
Yes, madam. Take it.
Choose.
7th month? If
You
7th
agree,
is
Mr. Mishra, you agree for a cut.
a short point involved. Okay.
Yes.
7th.
But they had filed objections before the learned single.
No.
Division. Call this matter on 15/7.
But
14/7. Okay. You have to tell under which law,
yes,
which statute these circulars are,
I'll just ask.
whether they have statutory flavor or they are just executive instruction.
I'll assist.
But Mishra argues in your favor. He says that the Director of Technical Education will grant. So then they have no say.
No, my lord, what happens? Unless they give me NOC, my portal will not be opened. And once portal is not open,
You cannot
take admissions money. So portal clearance by the central government.
When admissions begin?
My lord, it will begin from the session is now going on. 25-26 session will start just now. The admissions are going on. It will complete by end of July. 15th of July it will complete.
15th of July.
July.
Then we should have it a little early.
My lord, I was therefore praying before 7th.
7th, 8th. 9th we'll have.
Grateful.
9th.
Grateful.
Okay. Yes.
Mr. Das may look and pass over.
Pass over.
I'm in virtual mode.
Petition your lordship.
Huh?
May we to withdraw the petition with a
Counsel for the petitioner has filed a memo.
I'm filing.
Seeking leave of the court to withdraw the petition to revert to the court afresh if occasion arises. First up, liberty accordingly is reserved. Petition is disposed of as having been withdrawn. Any objection from your side?
No, my lord. I am here on.
Also
Yes,
Same. Same. You have to refer to the memory example. Okay. This will have after that, after reading the law.
But here the limitation is there.
Limitation is
Short
there.
limitation.
Limitation. Then the notice has to go.
Yes, my lord.
Issue. It's a police notice.
Yes, ma'am.
In all criminal matters, Apex Court said police notice should go.
Normally, whenever they are appearing on the notice, there is no need
Some
of
matters we saw by registered post, speed post.
speed post.
Issue emergent notice both by speed post and through police. Okay. Yes.
17 is, my lord, also same, but it delivered notice, it has been there, my lord. It has been solved.
Huh?
It has been solved. Sharply, 12 of 2000.
Sir,
My lord, this is solved on
we filed the
16/4/2025.
communication has to come on record so that we can say that is a 16/4.
Yes, ma'am.
April, sir.
April. So do you, but whether it is speed post or police notice? Police only.
Yes.
All right.
IAC has been served upon the wife of the accused person as he was absent. I have got the
Is service to the husband.
It's a criminal matter.
It's a criminal matter, na? In English law, up to 1881, wife was considered to be part of the husband, ardhangi, and killing wife was half suicide. If you read Kenny's outlines of criminal law, you will find such cases. But here, you cannot service how the rules say. In civil, any member of the family, if that is residing with the defendant, if that is served, it is held to be service. But in criminal law, that is not applicable.
The IAC, while serving the notice,
Steps. Service to wife is not service to husband.
because he was absent,
You should go and chase. Police should go and chase. That is the reason why police notice is issued.
then fresh notice should be issued.
Issue fresh notice through police. Returnable within 2 weeks.
62Y and 323. Let's say your lordship issued notice on 12/3/25 that as per the tracking report flag B,
That is a
high
police
damage delivered.
postal notice.
Yes, postal notice.
No, police notice has to go. Though it is submitted that the notice sent through the post is delivered to the addressee, ordinarily and consistent with the Apex Court view, notice in matters like this should go through the police. First off. Therefore, issue fresh police notice returnable within 2 weeks. Yes. Can any youngster say in which Supreme Court said in criminal matters the notice should be through the police?
So I can actually let my name.
Your DSG.
Now I'm DSG, but for EPF they have a separate panel.
Who appears for the APF?
If there is a lot of panels, I will intimate the concerned officials by the routing.
Tell one name.
I am one of the panel.
You are one of the panel
Yes.
Shri. So and so.
Dr. Purushottam.
Dr. Purushottam, learned panel counsel, on request accepts notice for the appellate. First off, name of learned DSG, therefore to be deleted. Okay. Be deleted. All right. At least papers you can have with doctor, whatever
I have
papers.
taken back all the briefs, everything. I did nothing over there.
Then how should
Empty
the
the
registry
department
to-
and get the all the.
From registry, you get the papers. The registry to furnish a set of appeal papers.
In the often instructions, this is a old matter. That is how we are listing it. Already listed
Dr. Soy.
twice before us. Dr. Chudi.
Problem.
Yes.
Maybe. The delay of 37 days in filing the appeal.
Sir, can we control the delay?
Finally, small objection for that reason.
You want to bring small objection?
Yes, madam.
What is the objection?
But so far as the time which has been some saying that the ill, there is no such documentary evidence to say that under whom you are undertaken, what type of disease are suffering. Para 3 of this. No, I'm not sorry, but my contention is like this to that extent. You will also have taken into consideration in that respect. But it is my duty to file an objection that no such document has been filed in that regard.
Yeah, but
37.
34 days.
34 days.
First. Yeah, that is fine. Unfortunately, it works. Then, delay is short and plausible explanation is offered for us. First, so objections
filed by the respondent to the subject application are also noted. First off, having done all this, we are of the considered view that the application be allowed. First, next, in the above circumstances, application is allowed when delay is unconditionally condoned. Yes, put it in the papers. Any argument on merits or some other day?
Some other day.
Call this matter in the first week of August. Okay.
Memo has not received. He said, my associate said, I will submit another copy. I will submit another copy. Today in course of the day.
Item 26.
Only 6 days till my now.
Notice has not gone.
No, notice is state government is
State government.
We have not received copy, we already copy received.
You receive copy, but we will condone that in 6 days. Give copy.
Yes.
One set of papers.
Well, before filing, I have already served the copy. Unless it would have been a different
Application supported by affidavit seeking condonation of a short delay of 6 days is favored after perusal. First, appellant to furnish full set of papers to the learned one more set of papers to the learned AGA. Right now. Now itself you have to give.
No.
Now it is before the sunset of the day. Yes,
Right.
Again for that no time will be granted.
My
Yes.
lord, 2 points are involved, my lord, if you want to do the operation of judgment. 2 points, my lord. I have retired since 8 years back.
8 years back.
Entire charges are framed on the basis of a preliminary inquiry dated 18/11/2013, mind. Rule does not provide that the charges shall be based on the preliminary inquiry, which on the basis of that no charges can be framed, my lord.
Which is that ruling?
That is the judgment, my lord. Rule, my lord, you will also kindly see Rule 16 of Odisha Civil Service.
Any judgment on that?
Yes, my lord. There is a judgment.
Mr. Mahanti, that preliminary inquiry was now, you are not party to that.
No, I am not part behind my back.
At the SOCO stage, when they started inquiry, they gave you the preliminary inquiry copy.
No. Therefore, this honorable single judge has directed that serve a preliminary inquiry.
So it is excessive natural justice or what?
Yes, madam.
Because they could have straight away started with.
They frame the charges on the basis.
No, not Which inquiry is initiated?
My lord, your worship can see. The inquiry charges were framed, my lord. I filed my detailed statement of defense.
Yeah.
Then inquiry was conducted.
Yes.
Regular inquiry.
Ah.
That they did not give me an opportunity to examine my witnesses, or they did not examine anybody, or did not exhibit any document. After inquiry report, my lord, that so-called was called for me or to file the representation, and file the representation stating that no opportunity has been provided.
To the report.
Yes. Then
Inquiry report.
yes, my lord. Then
After saying yes, you have to keep a little pause. You have to give us because you have to assess what is the consequence of your saying yes.
no, my lord, here that inquiry report was given to me.
That means inquiry was held.
Inquiry was held.
Inquiry was held. When inquiry was initiated?
Inquiry was initiated, my lord. The memorandum of charges was framed on 19 to 2014, my lord.
19 to 2014. And you filed your objections to this, reply to this.
Yes, my lord.
Reply is dated?
Reply is dated on 27/10/2015. 27/10/2015.
Thereafter, inquiry was held.
Inquiry was held.
Held means what? Who examined whom?
Marshalling officer did not examine any witness. No
witness, Mr. Pond, no witness.
No exhibit one.
Having the
Let
brief.
me do my complete one.
No, you give copies, then we'll have it next week.
Next week, and you lost it in this one.
No witness was examined.
No witness has examined.
From the side of management, nor from the side of yourself.
Yes, my lord. Only you lost it. Then, my lord, that I made a representation that no opportunity has been provided to me. The disciplinary directly for de novo inquiry. De novo inquiry was conducted.
What the report said?
Report said that yes, I have misapplied this amount, or 12 lakh sum has to be recalled from me, and that the pension 25% pension should be withheld from me. Then de novo inquiry was made. In de novo inquiry, my lord, no exhibit was given. The preliminary inquiry report dated 18/11/2013 was not also exhibited. Not a single document was exhibited. The officer who conducted the preliminary inquiry in his class agent stated that I have not visited site and I have given the report. And
That was relating to some civil work done, measurement, etc.
I am a range officer. I was a range officer, and I have been.
Anyway, you give copies of the paper, so we'll look into. Immediately, we are not with you now.
Then, my lord.
No, we are not with you now. We will not hear you.
But sir,
You give
3rd of July. 3rd of July.
My lord, not third, my lord, because I have to.
Which date you want?
2nd July.
No,
2nd July.
Yeah.
Fourth. Second, fourth, I will not be available because my nephew marriage.
7th,
7th.
7th, 8th, 9th, 10th.
8.
8.
Yes. You want password? Your password matter. 1-3. 1-3. Yes. What if you proceed in work for 2 password? Yes.
This is the fresh admission matter, my lord. The employee was reported without a due process of law. He has filed a representation, and against that order, he was to file an appeal to this honorable.
What was the post he was holding?
Junior clerk, my lord. Promoted
Senior
to the
clerk.
post of senior clerk.
Huh?
Promoted to the post of senior clerk.
His first appointment was done when?
She was appointed in 2019.
Full date has to be given.
Yes, sir.
It's not a year.
Yes, sir. 19/5/19. I was appointed and joined on
5/19 is the date of appointment.
Yes, I joined on 1/6/19.
1 second. Appointed as
Junior clerk.
junior clerk.
Junior typist.
Junior
typist.
I was promotion was
12/7/22. Senior typist.
senior typist.
Minor.
Reversion is
Reversion is 24, 27/4/24.
what is the ground on which she is reverted?
Minor. A senior employee in the feeding cadre, the junior typist, he was not given promotion. He was given promotion sometime in 2023. He never challenged my promotion. What he has done, when a gradation list of the senior clerk was published, taking my date of entry into the senior typist post above. So he said his claim before the authority is that I should be placed below him. That is his
in the seniority list.
Yes.
One
He
second.
challenged the seniority list.
1 second.
Yes.
Whether this promotion took place on the basis of seniority list?
My lord, that exactly I have no knowledge.
Without
What I
that
say, my
knowledge,
lord,
you
I have
cannot
given,
argue.
I am a woman.
You may be woman.
I have got a promotion by the authorities.
You have to,
I have no personal knowledge.
you have to answer that question. Because any standard book on law of
So, my lord,
service,
that is the rule is, my lord, merit comes seniority. With due regard to seniority.
therefore, that there has to be seniority.
Fine. So what happened, my lord? The fact of this case is the gentleman who has made the complaint with regard to the gradation list of the seniority list, he never challenged the promotion. What he filed is a representation. I was asked.
Matter is covered by Karnataka High Court, Kathe Gowda versus State of Karnataka. Go to Google.
Well,
Identical question is answered by Karnataka High Court. Justice Rama Joyce has dedicated 2 paragraphs on this.
well, but my case is something, another 2 lines. My lord, what happened, my lord? On 27/4/2024, I was directed to be reverted. And but by the time, my lord,
One thing we do not understand is when judges say some jurisprudence,
my lord, I have
why
taken
can't
note
you
of-
make
I have
research?
verified.
You need not go down at all. You can stand tall and say, I will go to the library and look into.
Yes, sir, but I have taken note
This
of
is how knowledge is gained.
Yes, yes.
By interaction, by reading, by traveling. Is it not? Judge is saying it with name of the court, judge, decision also. At least you can hold this to the judge when he walks in the corridor. Sir, you have said this judgment. That is not correct. That courage has to be shown. Is it not? We are telling
My lord.
name of the case also.
Yes, yes.
We are telling the books. We are telling how many paragraphs are dedicated on this by learned authors like Samaraditya Pal, Kulashrestha, by Justice Rama Joyce. At least 3 important books on services under the state are available. Just look into. That may help you.
Yes, ma'am. I will go through that. My lord, I will come back, but one more fact I will close clarify in this particular case.
Yeah.
Though they have reverted me on 27/4/24 on the allegation of the senior, but in the meantime, 2 other juniors to me have also given promotion. So, because I have not taken promotion by practicing fraud or any manipulation or maneuvering things, they have given the land DTS has given me the promotion. So now they are recalling on the basis of a representation. So at the same time, so I have immediately represented to the authority when I faced the reversion. That look here, 2 other juniors have in the meantime given promotion after me. So I should have been retained. Because last come first book, yes. So see, he or she should have been reverted back. I should have been returned back. But instead of doing that, what he has done, he didn't pass any order on my representation.
Anyway,
Again, I filed an appeal. The crux of the issue is, I filed an appeal because there is appeal provision under the rule to this honorable court.
Statutory appeal.
Yes. So what he has rejected my appeal, say that appeal is to be filed within 90 days. You have filed beyond that date because I was waiting for the result of my representation to the same authority, land decision. So he now rejected my appeal to this honorable court.
On the ground of
It is
limitation.
It is
Appears to
far better. That is the difficulty.
appears to be little unkind. On limitation, appeal could not have been rejected. Who appears for the other side?
My
For the state.
2 important things he has made out. Number 1, juniors have been promoted. And he has not played any fraud in getting the promotion. Number 2, the administrative judge rejected.
It is not reached, my lords. Here. The district says because of the provision under the OCSCA rules.
Within time you are not
27. Appeal is to be filed within
no period for condonation of delay.
So that's the appeal was to come to the appeal committee.
Through proper, yes, through proper channel.
How can he,
Because it has to come through proper channel.
no, can he take a decision that we will?
Yes, that is 27(2), my lord, that kindly
There is a
regards to that.
provision.
Rule 27.
It says
He has referred to
should
that.
be routed to through the judge and he can
Send it to committee.
Yes. Please,
Prior to that.
Well, in Karnataka, there is such a rule. I do not know. Generally, these rules have common patterns all over the state.
27.
Read that provision.
Right, just
yes.
Withholding of appeals. The authority
He can
which made
withhold
the
the
order
appeal itself.
appeal against
Okay, understood.
may withhold the appeal.
He may withhold the appeal.
If it is
Withholding of appeal.
yes, against an order,
Yeah, it is like postman withholding my money order.
yes, because it is beyond time.
That appears to be legal. That was a colonial piece of rule. Condone, if we allow this petition and ask him to send the appeal memo to the committee, anyway, we cannot take decision. There is a statutory appellate committee. Will you be satisfied?
I have a more suggestion.
Yes.
Can I suggest? My respected submission, my recommendation to the learned decisions at the outset was before the appeal, my lord. I says this reversion. I do not
Anyway,
object to the seniority of that gentleman. But
Yes.
other seniors have got the promotion.
That's what
Consider
Therefore, all that will be considered by the committee.
Yes, committee can also, because
Can we do
why I will bother the honorable court, the decisions can decide.
It was a temporary promotion to the senior typist.
No, regular.
My lord,
No,
that is also annexure,
Yes,
Para 16 page 20.
annexure
Yes.
20, page 22,
I'm asking.
serial
It
60.
is temporary.
Then what?
But even then,
Deputation of Divyarani.
huh?
No,
Paragraph 16, page 22, annexure 2.
So that's, am I referring to the correct paragraph or you are referring to something else? That I'm asking.
Para 16, yes.
Para
yes,
16.
That is always written in line. Deputation of Srimati Divyarani, junior typist of the Court of Senior Civil Judge, SHA Women's Court. Now I got to the
Those are
Court of
not
Judge.
temporary. It is going ad hoc
He is
or
promoted.
subject to confirmation or
He is
confirmation
promoted
that is
temporarily to the
for a-
grade. This is the what they use.
No, deputation is withdrawn.
No. Deputation is not.
Whose
On
deputation?
On deputation, I was in a junior typist court, in another court. He has withdrawn from that court and given me a promotion on temporary basis to another court.
One second. Withdrawn. Srimati Mohapatra is promoted temporarily to the grade of senior typist, carrying the pay under Rule 7 of pay matrix given to the. Anyway, it's a temporary promotion.
That is
What was
always they use.
Huh?
They use that word, man. The particular promotion.
No, temporary promotion and promotion. The Supreme Court said
That is there,
There are
but
two different
these type of cases. They use it.
because you say it is a merit cum seniority.
Yes, that is the rule.
In case of merit cum seniority, seniority takes the back seat. And even when you are senior, your juniors may be promoted because they are found more meritorious. If it is seniority cum merit,
Yes.
you can say as a matter of seniority,
Yeah,
you
right.
should be given promotion unless there are some reasons why it cannot be given to you. That's the law.
Well, there is no quarrel about this.
Stop. Roll up. ऊपर को जाना. Second. So can you do the Here it says. So that's, are you aware, there was a departmental promotion committee given selection process was done
For me.
for all. I mean,
Yes.
you are not the only person.
Yes. Many persons are given
Yes.
promotion. I was also considered by them.
17, to be
Yes.
precise, 17
Yes. I was one among them. And I was considered and promoted. Got the benefits also. But now by the order, they have recovered the amount what I have get in excess. So my lord, the drop.
Recovered also.
Yes, recovered.
Can they?
Though I have
K.R. Singh's judgment. 2012 or 13?
Yes.
2015.
15?
Yes.
Okay.
15 years.
It is so. We'll remand this matter and set aside that order.
Exactly.
And let the district judge forward the appeal memo to the committee.
Committee will take a decision on its own.
On its own. Committee comprises of High Court judges. Be seated. Be seated.
Right.
Vashanto. Correct? Vashanto. Petitioner was appointed as a junior typist by order dated 19/5/2019, and he reported for duty on 1/6/2019. She did it, and she reported for first. She earned the promotion on 12/7/2022 as senior typist. First. However, while order dated 27/4/2024 made by the district judge, yes, ma'am, by the learned district judge, she came to be reverted to the original position of junior typist. First one. She had made a representation against the same. First one. Thereafter, she had preferred an appeal as provided under rule.
Then just
Sit down and say, this is not primary school. We are all partners in the judicial process.
This is valid under the CCA rule because the proceeding
This is that rule. We are asking you.
Rule 23.
Okay. Under rule so and so. Give that, just write down and give.
Yes, sir.
Give a small check to learned friend. Before the, to the appeal committee, ordinarily headed by administrative judge of this court. Appeal committee of the appeal was presented to the next paragraph. The above appeal was presented to the district judge so that he would forward the same to the appeal committee. First, to the dismay of the petitioner, that forwardal did not take place, allegedly on the ground that appeal was filed after the expiry of limitation period. First, we are told at the bar that the district judge ordinarily has power to withhold the appeal
27.
in terms of Rule 27.
Rule 27 of OCS CCA.
OCS CCA rules.
1962.
1996.
62.
1962.
1962. Above also you have to write that. Learned counsel for the petitioner submits that withholding of appeal of the kind is a serious matter. Strong reasons have to be assigned for the same. Even if appeal is time-barred, the appellate authority may entertain it after condoning arguable delay. First off, from any standards, the action of the respondent district judge is not fair and just. First off, he also adds that after the reversion of the petitioner, 2 of her juniors have been promoted as a senior typist, disregarding consideration of the candidature of his client. First off, according to him, this is nothing but adding salt to the injury. Next paragraph. Learned AGA, on request taking notice for the respondents, opposes the petition making submission in justification of the reasons on which the impugned order is structured. First off, he argues that though the right of appeal is a statutory right and a substantive right, if the same is not preferred within the period of limitation prescribed by law, the right dies, and therefore the action of the district judge in withholding the appeal cannot be much faltered. First, he also contends that the promotion granted to the petitioner was only on temporary basis, and ordinarily a temporary promotion is not a true promotion in the realm of service jurisprudence. Semicolon. If a temporary status is taken away, much grievance cannot be made out. First, so contending, he seeks dismissal of the petition. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned counsel for the petitioner that withholding of a service appeal by a mediary is not a happy thing to happen. First off, there is power to withhold appeal in terms of Rule 27 cannot be much disputed is true. First off, existence of power is one thing and its exercise is another. Brother, how that word you just the section uses the word may withhold or shall withhold? Learned counsel is right. Counsel appearing for the petitioner is right, drawing our attention to the terminology of the subject rule, which employs the word may as distinguished from the word shall.
Under Rule 27.
First. May ordinarily involves discretion. First up.
For is the limitation condition.
Okay. Ordinary, what you written? Ordinarily, may implies discretion. Say, the sages of law, like G.P. Singh in India, Maxwell in England, and Crawford also. First, this discretion is not a Mughal discretion. First, Lord Halsbury, in the case of so and so, held that discretion means according to the rules of reason and justice. I am not whimsical. First, reason and justice are lacking in the impugned order. First, that is the first faltering foundation stone. First, next paragraph. Learned counsel for the petitioner is also right in drawing our attention to clause 3 of Rule 27, which makes the power to withhold appeal dependent upon non-furnishing of reasonable cause for the delay proved. First stop. In other words, the power availing under Rule 27 is not absolute and it is conditional. First stop. Unless these conditions are satisfied, the discretion to withhold the appeal cannot be sustained. First off, in departmental appeals, we add, aspect of delay takes a different color than in civil litigations. More particularly when Article 12 entities are the employers or what? The disciplinary authorities. First up, it hardly needs to be stated that the state entities under Article 12 of the Constitution have to conduct themselves as model employers, as observed by the Apex Court in Bhupendranath Hajaria versus State of Assam. Sorry. This standard, this fair procedure, it does not appear from the records as having been adopted. First time. Next paragraph. Perusal of the records does not much disclose as to how the reversion of the petitioner could have been sustained when two of her juniors have been promoted. First of all, arguably, these are the cases of promotion on merit cum seniority, on the basis of merit cum seniority as distinguished from seniority cum merit. First of all, be that as it may, we do not undertake a deeper examination of this aspect since it pertains to the domain of the appellate committee. To a domain of the authorities. First of all. Next part, in the above circumstances, this petition is allowed in part. The writ of certiorari issues, quashing the impugned order of the learned district judge. Certain matter is remitted to the portals of the district judge, who shall refer the appeal in question to the jurisdictional committee, keeping open all contentions for consideration. First, no costs.
after death of my father, I've applied for the Administrative 4 series for my appointment as rehabilitation assistant scheme. That was rejected by the
Compassionate appointment.
man.
That application is rejected.
That was rejected.
Your client's father died in harness.
Man.
What was he?
He was the Shirastadar.
Father was Shristadar.
Man.
He died on which date?
Died on 27 January 2016.
How many years of service he has put in?
He has put in 17 years serviceman.
So, what is the qualifying service for pension?
10 years.
10 years. So, 17 years, how much? What is the money he got? Terminal benefits, family pension? What is the amount?
That was not calculated, but according to that calculation, as in the improvement order of that he's getting 1,73,160 rupees from pension. On page 44.
Pension?
Total annual.
Even judge's pension is
annually. That's annual.
Annual.
1,73,160 rupees.
1,73,160
rupees. It is mentioned in the improvement order also.
Improvement order it is mentioned. Go to the improvement order.
Particularly page 44. Running page 44, para VI. Last line.
34.
44.
This your application you have filed 2 years, 7 months after the death.
Minor. According to law, that I was at that time I was not major. According to the law, it was 3 years time to file the application. So
total terminal benefits, how much money you have received? How much money you have received? Annual income, you yourself have now 1,73,160 by way of pension. Then what is the terminal benefit? After his death, some lump sum amount will come to the hands of the deceased, to the estate of the deceased.
That is not.
How much money? That you have to quote to say that. What is the amount is given to them?
No, I am not in
17 years, DCRG, EPF. How much money is paid to the lady?
I'll obtain instruction. I'll collect that information. I'll place it before Lords.
Call this matter next week at the request of, call this matter on so and so, some date you, at the request of learned AGA. First of, okay. Because Apex Court says, if lump sum money given by way of terminal benefits is very high, no right of compassionate appointment.
That suffices the survival.
This is right. Compassionate appointment, the intention is to tide over the economic disaster which the family will be befallen because of the death of the breadwinner of the family in harness. That is the idea. Not right of employment. Yes. Next. Bring that judgment also.
Yes.
Yes.
Item 37.
37. Yes, sir. Yes, sir.
3 appeals.
3 appeals.
3 appeals. Directed against the judgment of the Honorable Single Judge.
Very same judgment.
The same judgment.
3 appeals by 3 different persons.
No.
Same person.
This is the background is like this.
Okay.
There are 2 writ applications were filed. Challenging the advertisement made by the state selection board, and the question which was involved in the advertisement is whether the qualification prescribed by the state selection board in the advertisement, whether it is in consonance to the UGC regulations. The Honorable Single Judge was one advertisement. So far the other advertisement is concerned, the Honorable Single Judge, since already
the selection process was already high and already selection was made and appointments were already made in respect of different subjects except physics. So the Honorable Single Judge allowed that the appointment should be made in terms of the advertisement so far as that physics is concerned. And that has been challenged in the second writ appeal by some candidates here. But the first one is those who have already offered their candidature pursuant to that advertisement made by the State Selection Board. That is the subject matter of dispute. They have filed an application for grant of leave, and he also granted leave because they were not parties. They are not parties, so he also allowed that application already. Now, state has filed an appeal. The third one, state has filed the appeal challenging that judgment, saying that the state has the power also. State has not accepted so far as the Raja Lordship knows that to judgment of Jagdish Prasad Sarma and other judgments. Relying upon that judgment, the state case is that these are all block grant schools, grant-related schools. So they are governed by a set of rules framed by the state government, one rule. So far as the qualification is concerned, they are not bound by the qualification laid down by the UGC because they are paying the state scale to these teachers, to lecturers.
One second. In other words, the UGC regulations apply to the conditions of appointment, recruitment, only when UGC gives the grant and not the state. If state is paying or reimbursing the salaries,
that is the state.
Then UGC cannot prescribe the qualification.
Exactly
this is answered in the negative by the apex court.
So far as the apex court judgment is concerned, that judgment, if you also see, since the education in the concurrent list and state has the domain also to make its own rule, so far the qualification is concerned, so the qualification laid down by the state government will prevail in respect of these colleges.
Is it with the assent of the president?
No,
You are referring to... No. Question is, you can't read 309 proviso independent of distribution of legislative powers. UGC, as you rightly said, after the 42nd or 39th or 42nd amendment, education is brought down to concurrent list. But in the concurrent list, already field is occupied by the UGC Act, number one. Then the rules that are promulgated under proviso to 309 are relatable to concurrent item only. It cannot override unless there is assent of the president. The rules are made or the law is made under 254.
Conflict definitely.
Yes, as between central law and state law, in respect of matter relating to concurrent list, the central law will prevail over the state law unless the state had obtained assent of the president to the bill instead of assent of the governor. That is the law. This is what the Supreme Court has said, that many judgments. I think the Karunanidhi versus Union of India. Yes, proposition this one.
But,
if that is so, now what remains?
The whole thing now to be decided in this case, because large number of, so far the Odisha state is concerned, large number of aided educational institution for a different type of aided educational institution, one is block grant. So far the state scale is concerned, they have fixed a prescribed scale, so far these institutions are concerned. So that is why they have made the advertisement giving the scale of pay made for the state scale for the lecturers.
No,
so far the UGC scale is concerned,
it is not question of scale. UGC, the apex court said in 3 judgments, they are available. In 3 judgments, apex court said UGC is the nodal body to ensure upgradation of educational standards in all educational institutions.
That's it.
And educational standards are relatable to the prescription of conditions of recruitment. Suppose we want Palkiwala to be teacher in a law school. If that standard is prescribed by UGC, you are bound to abide by that.
Correct.
You have one option. The institutions have one option. Since they are paying the salary and it is not being reimbursed by the UGC, in such an event, in addition to the conditions which the UGC has prescribed, state can prescribe additional conditions. That's the law. That is the law. At least there is a big line of a curtain of decisions of apex court on that.
Therefore, the whole question for constitutional lordship, I have understood that whether the state laws with regard to the condition of service of the teachers, lecturers and teachers, and their scale of pay, and without those teachers are not getting the scale of pay from the UGC. UGC is not extending the UGC scale so far these colleges are concerned. Rather, that is a block grant. A portion of the scale is borne out by the management, and the rest of the scale was given by way of block grant by the state. So in such a case, they have prescribed a rule that state, of course, it is pursuant to an act, this Education Act. They have made a rule that is for the state to place before lordships.
These are not 309 proviso rules.
Exactly, it is not 309, but it is pursuant to the
some
yes.
Other day,
So
my brother was saying there is a Orissa Education Act.
Because that
Orissa Education.
Orissa Education Act 1969.
69.
So it is
is it enacted?
With the assent of the president.
With the assent of the president?
Yes. Orissa Education Act itself is the assent of the president. So therefore, it is a far-reaching consequence. So it has a.
That was
prior to even, I think, amendment
to the constitution.
I could not tell what is the conflict then.
Where is the conflict between?
Conflict
because who are the agreed parties?
According to us, there is no conflict. According to us.
Yes.
But so far as this.
No, suppose they are overqualified.
Yes.
Are they debarred from appearing and competing?
No.
Well, perhaps this question.
Now the whole question is.
Can we figure out
better because my learned friend also wants some time to take instruction in this matter. In fact, my learned friend was suggesting us. I was just
2 weeks if the lordship will fix. The lordship can hear us out.
Yes.
Yes, broadly now we have
exactly.
bone of contention.
It was not so. Yes.
No, you argued well. Therefore, we could understand.
That is exactly the.
Yes.
I was talking to my learned friend also.
We'll take a date.
Yes, sir.
Pull down a date from the calendar. On that day, we will finish up the matter. No date will be given further.
After 2 weeks.
Kindly take a pull down a date from the pool.
July 10th.
10th of July.
Yes, July.
We have kept
many matters.
11th.
11th or 17th.
My learned friend is
the next
11th, 15th, 50th. 70?
Okay.
70. Oh, thank you. Give the judgment. So the law is much settled. Much of the law is settled.
Absolutely correct. My only question is that is a
conflict or not. Conflict may arise. On that itself, there are judgments. Right. Shirvai writes.
So that's right.
Conflict may arise not only during direct conflict. He gives wonderful example. Central law permits 5 liters of petrol. State law permits 3 liters of petrol. Is it a case of conflict or not? So beautifully he has discussed in 4th edition, Shirvai's constitutional law. Very, very, this one.
Yeah, appearance may be noted. I am for the UGC. Yeah, appearance may be noted.
We will not note anything now. We will call this matter on
other reasons.
So please write your, in the paper because there's so many cases, so they will be public. So in each case, please write whoever are appearing, including us.
That way. Okay.
The rest of the matters,
Rest of the matters will distribute.
Consent of the parties list on 17th.
70, consent of parties, what's
17th.
My lord, item 43, my lord.
43.
My lord. Let it come on 22nd July, my lord.
So, can you
Second July.
give him some latitude? He has some difficulty in the calendar.
We have already posted matters.
Second-
Therefore, just see.
The see, it is not going out of the list. No matter is going out of the list.
Just have a word with the court officers.
Lord, item 40, this is very peculiar matter. Husband filed divorce at Bhubaneswar.
No, correct. We are
Come tomorrow.
not tomorrow. They will be distributed.
My lord.
Almost all matters are hearing.
Date may be fixed, my
I
lord.
will just you have word with the court officer. They are court officers. You can have a word and they will push some inconvenient date.